Well, good morning, everyone, and thank you very much for attending this King's Young Professionals Seminar. For those who haven't attended a KYP talk before, well, for those who have, welcome back. For those who haven't, just by way of a brief introduction, they are intended to be as informal as these things can be, and really just a briefish talk on an area that may be of interest or use to those particularly at the slightly more junior end of the legal profession, but of course, really all are welcome. Just by way of a very brief introduction to me, I'm a junior member of the business and property team here at King's Chambers. I really work across all areas of that team, but in particular, general commercial work, insolvency, corporate and company disputes and property. I'm based in Leeds, but as they say, will and do regularly travel. The focus of this talk is a relatively recent decision on the law concerning onerous terms and contracts, but really I want this talk to give you a toolkit of three ways in which contractual terms in business disputes might be challenged, to use a slightly euphemistic word. It is something of probably a brief refresher really on areas that we'll undoubtedly be familiar with, but at least in my experience are sometimes not necessarily always thought of in these situations. If you're looking for an authoritative jurisprudential analysis of the law here, I'm sorry, you've come to the wrong place, but I do hope to at least jog your memory and give you some sort of food for thought and also tools to use and apply. Why do I think it's useful to know about these things? Well, certainly in my experience, it is a common situation in practice to be advising on either side of a dispute where one company has contracted with another to provide goods or services, often services. Usually the smaller company has filled in an order form referring to the supplier's often voluminous standard terms and conditions. The client probably doesn't read them, but even if they do, they at least don't try and normally negotiate them. They simply sign what they need to sign and off everyone goes. That's all well and good until, say, the purchaser is unhappy with the service for whatever reason and say they want to get out of and cancel the contract. And at that point, they, or perhaps more likely you as their lawyers, wade into those standard terms and conditions and find that to even cancel the contract, you need to give written notice delivered by carrier pigeon to the company secretary exactly 6 months to the day in advance. And your client's heart sinks, and probably your heart sinks as well. So what you are faced with can often seem like a sort of David and Goliath situation, hence the picture there in the slide, because Goliath, with its 30-page terms and conditions, seems like it has the upper hand, and your client David has nothing more than a bit of pluck and a signed engagement letter from your firm. But we all know how the story ended. And if you do really just take one thing away from this talk, I would suggest that it could just be the short list, because that, I would suggest, is a sort of three item toolbox. And when you're faced with any scenario where you have an issue with a problematic term, you can apply each tool to this problem to see if it fits. They might not, but even if simply one does, it may be enough. Right, so on with it. What is an onerous term? Well, a very brief couple of historical slides back to our collective days of studying law, and this quote from Lord Denning, there he is, and his famous red ink and red hand quote from J. Sperling and Bradshaw. This statement here wasn't a novel statement in legal terms. It's really an old common law principle, but this is a justifiably famous quote, and it's a good line, which frankly sticks in the mind. Fast forward about 30 years from the 1950s to another judicial legend, Lord Justice Bingham, as he then was. And we have the case which is, I think, most often cited as high authority for the principle, interphoto picture library and stiletto. And there in red is a neat encapsulation of the two factors as to what makes an onerous or unusual term. Firstly, an unreasonable and extortionate clause, and not one which is brought fairly to the contracting party's attention. That, in essence, is the principle. It really just boils down to two things. Firstly, Is the term particularly onerous and unusual? Secondly, if so, was it fairly and reasonably brought to the other party's attention? The first limb is quite obviously clause sensitive. It's difficult to give guidance in the abstract, and I'm not going to focus on that. To a large extent, you probably all know one when you see one. So using the example of a customer trying to cancel a contract from earlier, you're probably looking at something like an unusually long notice period by reference to the actual length of the contract, an unusual prescribed method of cancellation, say fax in 2022, or perhaps even something more dramatic where the supplier apparently has the discretion to refuse to accept the cancellation ever, which I think I once saw in a contract, and it certainly raised my eyebrows. It's probably a combination of gut instinct, but also, if it's marginal, and if you can, analysis by reference to authorities. What I'm going to focus on more is the second limb. I think it's more interesting, and we can extract some useful principles from the cases. And to do that, I want to discuss a relatively recent decision of His Honour Judge Stephen Davis, sitting as a judge of the High Court in Manchester, so a local hero, in Blu-Sky Solutions Ltd and Be Caring Ltd. It is a nice case because, as far as I'm aware, and I checked again this morning slightly nervously, but as far as I'm aware, it's the most recent reported English authority on onerous terms. It's quite short. The discussion on onerous terms is only a few paragraphs, and it synthesizes and discusses two High Court authorities, which I've named there, which, if not quite sitting in tension, perhaps could be said to offer arguments in different directions. It also discusses and refers to Good Life, which is a more recent Court of Appeal authority. And I think I said at the start, before perhaps everyone joined, but I should say, even for a barrister, I'm probably already citing too many cases for a 30-minute talk on a Wednesday morning. As I said, the slides will be circulated after this, so don't worry about taking any notes. You probably weren't, but you will have all the references there later. And certainly I would suggest that in this area, these 4 cases probably represent all the cases you will ever need. So I've put them all there down just for completeness. But why is Blu-Sky worth discussing? Well, the facts are, I would suggest, potentially quite applicable to many a situation. Essentially, you had, there was a business customer, Be Caring, which was a social care provider, and it signed a purchase order on a mobile phone supplier's website for a number of handsets, which said the following: by signing this document, I agree I have logged onto the supplier's website at a link, have read, agree, and fully understand all terms and conditions regarding the contract, and blah, blah, blah. So pretty standard fare, which I'm sure we've all seen. The customer then placed an order for 800 mobile phone connections, then sought to cancel the contract before connection to the network. And at that point, the supplier sought to say, aha, well, please see our terms and conditions, where you will find a clause allowing us to charge a cancellation fee of £225 per connection. So quite a significant sum of money. The first issue was whether or not the terms and conditions on the website were even incorporated as a whole anyway. And on this issue, the judge found in favour of the claimant company, Blu-Sky, because if one went to the website, the terms were available and could be clicked on and were accessible. So perhaps an early goal for Goliath. But in the end, it was a second half comeback and a victory for David, because the judge concluded that the relevant cancellation clause was both unduly onerous and one that had not been fairly and reasonably brought to the attention of the customer. The effect of that was that the clause was not incorporated into the contract, could not be relied upon, could not be enforced against Be Caring. The fact that the clause was onerous, probably not surprising on the face of it. And I think, interestingly, the judge applied similar considerations to the old iteration of the penalty clause doctrine, i.e., essentially the cancellation charge bore no relation to any loss actually suffered by the mobile phone supplier for Be Caring trying to cancel the contract at that point. So if you are trying to figure out whether a clause could be onerous, that might be a useful first principle to consider. Interestingly as well, I think the judge didn't actually have much truck with the notion that this clause wasn't onerous, because these sorts of charges were fairly industry standard terms. They are, but that doesn't in fact mean they're not onerous. On the second limb, so was the clause fairly and reasonably brought to the attention of Be Caring, the judge was particularly persuaded that this was or persuaded by the fact that this was a clause which was firmly buried within a dense thicket of terms and conditions. And the judge stated that even for a lawyer, the terms and conditions were difficult to read, interpret, and disentangle. There was nothing, simply put, like Lord Denning's red hand, and nothing even like what you sometimes see, which where the terms specifically say at the top, your attention is particularly drawn to the following clauses. So all told, the fact that a signed order form refers to terms and conditions is itself insufficient to get around the problem of notice. So what about this synthesis of High Court authorities sitting in tension? Well, we're all familiar with the principle that if you sign a document containing terms, even if you haven't read them, you're generally bound. Limited exceptions, very limited, safe address, extreme time pressure, misrepresentation is what the term said. Well, the cases of Dubai and Bates, which I referred to earlier, came to slightly different conclusions as to whether or not the onerous terms principle, as a further exception to that usual rule, applies to terms which are not within the document signed, but appended or incorporated by reference. I'll skip to the conclusion. Essentially, Judge Davis in Blu-Sky, having reviewed both authorities, preferred the approach of Mr. Justice Fraser, which was the less restrictive approach. There is actually a nice quote from Judge Davis on this. I should say I'm generally loath to put quotes from cases in talks like this. I realise I've done it a lot already, but anyway, here it is. The part in red, I think, is good. I like the language of a signature simply being a factor when considering sufficiency of notice, albeit a very powerful one, and the concept of a sliding scale. A sliding scale approach is exactly how I would personally think about it. It avoids bright line decisions and really forces you to focus on the full context and everything about how the term came to be there. It certainly doesn't make an analysis of whether a term is onerous or unusual easy. There'll be a lot of litigation risk either way, but I think it's more likely to get a better result. So, summarizing onerous terms then, if you are faced with a problematic term and it seems onerous or unusual, is it incorporated? Well, I would suggest it's really all a question of notice. The first question to ask is, has anything been signed? If nothing's been signed at all, then things are obviously looking quite good for David, because the question of notice is there, I think, harder for the person seeking to rely upon the term to get to win on. If there is a signature, look at where it is relevant to the term. If it's beneath the list of terms at the bottom and that's a short list, then it's probably going to be difficult to argue that there's been sufficient notice. That's a powerful factor against conclusion that the terms were not brought to the attention, but not necessarily fatal. If, however, which I think is a very common situation, the offending term is incorporated by reference either in T's and C's separate from the order form, or even just not provided and referred to on a website somewhere, then now we definitely are sliding around on that sliding scale. Once you've found the term, look at the other factors, look at the red hand of Lord Denning, how prominent is the term, is it highlighted, referred to, put in bolds, put at the start, capital letters, referred to elsewhere. All of these things are things which might tip the scales, the sliding scales, one way or another. As to whether or not the term is actually onerous or unusual, well, to some extent, you probably have an idea when you see it. Industry practice is not necessarily conclusive, might be a factor, and perhaps you might consider similar considerations as to when considering a penalty clause, i.e. is it a genuine pre-estimate of loss? So that deals with well, I say deals with, that's a brief overview of the current law, where I would suggest that stands in the law of onerous terms. Not a lot of authorities on it. It's quite interesting, quite a powerful tool potentially, given that it can apply to pretty much to anything. Unfair Contract Terms Act 1977 is what I will next discuss. I'm afraid you know this section might be slightly dry when the only image I could think of was a photo of the Act itself, but there we go. The first point to emphasise with UCTA is actually in the long title, if you can read that beneath the name of the Act. In my experience, it's a relatively common misconception, especially amongst, I think, commercial lay clients who've perhaps heard of the Act. But the Unfair Contract Terms Act does not apply, confusingly, to all unfair terms. It only applies to those which purport to exclude liability for breach of contract or misrepresentation. So the earlier example given for onerous terms where a client is simply trying to cancel a contract, so the Blu-Sky example, that term was not within the scope of UCTA because the non-cancelling party is not trying to exclude liability for breach. They're not actually in breach of anything. So what does UCTA do? Well, firstly, I think as is well known, it entirely precludes contractual exclusion of liability for death or personal injury. Personally, I've never seen a clause which purports to do that, even in practice, but that's quite easy. The rest of UCTA effectively presents parties from excluding liability for various things, being negligence, breach of statutory implied terms, and contractual liability, which is excluded pursuant to some written standard terms. Unless, and that unless word does a massive amount of work in this statute, the term satisfies the requirement of reasonableness. So for the purposes of section 3.1, which is the written standard terms part of UCTA, which is what we're really focusing on here, it is actually very important to consider whether parties are dealing on their written standard terms, because if they're not, UCTA doesn't apply. This isn't a binary thing, and the courts will take a common sense approach. So sometimes it will be very obvious. At one end of the spectrum, for example, a contract like that in Blu-Sky, which is entirely standard. At the other end of the spectrum would be an entirely bespoke negotiated contract. That would not be within the scope of section 3 of UCTA. But I say it's not binary because the courts have also held that even if there is some negotiation and alterations for parties' usual standard terms, those can still be standard terms. And there is some authority that even if a contract is essentially cobbled together, with each party contributing some of its own standard terms, if one party inserts its own standard limitation clauses, then UCTA will apply to those clauses. But it's just something to check. So back to this requirement of reasonableness. What on earth does that mean? Well, no surprise that the statutory language is frankly an absolute open door for judges to use their judicial discretion. Section 11.1, the term shall have been a fair and reasonable one to be included, having regards to circumstances which were or reasonably to have been known to or in the contemplation of the parties when the contract was made. What does that mean? Well, the courts will and can have regard to what are called the Schedule 2 factors, which are within the statutes. I've listed them there. I'm certainly not going to read all those out. But for the purposes of standard terms, written standard terms, I would suggest that subparagraphs A and C are probably of the most use. A, because often you might be acting in a David and Goliath type situation, and often Goliath simply doesn't negotiate on his standard terms. Also, when you look at that language, you can have regard to probably how monopolistic the industry might be. So, for example, if your client has bought a very specialist piece of scientific equipment, which only really one company in the world manufactures, that company will obviously have the stronger bargaining position, as there would be nowhere else for your client to go. Subparagraph C, you ought reasonably to have known of the existence of the term. Well, again, that's probably similar factors there to when considering onerous terms in terms of sufficiency of notice, but it also does expressly refer to custom of the trade. Is case law of any use in determining the requirements of reasonableness? Well, perhaps like a deputy district judge in a 30-minute application hearing who's just reached page 7 of my skeleton argument. You might at this point be absolutely sick of case citations, but you might be relieved to know actually that authorities are of much less use in this area. And I appreciate the immense irony of citing a case to make that point, but that principle does actually come from the George Mitchell case. So don't worry, basically, about finding loads of cases to justify your advice in this area. Having said that, on I go with more citations, really just to make 2 points. Firstly, there is good authority, high authority, that the equality of bargaining power point seems to be a factor that courts will attach particular weight to, probably for obvious reasons. Secondly, these are the case at the bottom, the third bullet point there, because it is, in my experience, quite common to see these in practice. Clauses which limit or restrict liability to a certain sum, usually one which bears some relation to the actual contractual price, are more likely to be found reasonable. That's not a hard and fast rule, but as I say, the 2 authorities there where that's effectively what was found, and so it is something to bear in mind, and you do quite commonly see them. So that was a very brief trot through up to 1977, and this is now finally going to be an even swifter trot through the world of penalty clauses, which also gives me an excuse for a topical photograph. Right, and I'm going to read this out because I think there's a lot in it. The definition of a penalty clause is that it is a contractual provision which imposes a detriment on the party in breach of a primary obligation which is out of all proportion to any legitimate interest of the innocent party in the performance of that obligation. So if a client ever asks you, well, what's a penalty clause? Just say that. That is from the Supreme Court, I think it was Lord Sumption, in the co-joined appeals in Cavendish Square and Parking Eye. It is masterful, I suggest, both in its brevity and the amount of time that any practitioner needs to spend unpacking each word, which is what I am now going to try and do. This is a massive topic. How often it actually ever comes up in practice, you might have a better insight, to be honest, than I do. I've never argued this point at a trial or application. I've maybe pleaded it somewhat speculatively on a couple of occasions, but it is a potentially quite powerful tool. So at the outset, do bear in mind, and this probably applies to everything I've said today and talked about today, English courts and judges like to be known for upholding contractual freedoms. The penalty clause doctrine is a common law doctrine which interferes with that, so it will be applied sparingly. That said, how do you apply this doctrine? Well, firstly, you need to determine whether or not the clause is within scope. It only applies to what are called secondary obligations, i.e. those which are triggered when a primary obligation is breached. The easiest example of that would be a liquidated damages clause. So if you breach the contract, you pay me £1 million. Payments of £1 million is a secondary obligation, and it only kicks in on breach of whatever primary obligation it is. It does not, the doctrine does not apply to, say, a clause which specifies one price if you pay for the goods or services within, say, 7 days, and a second price if you pay within 14 days or after 7 days. Because there's no breach of a primary obligation there. There are 2 alternative primary methods of performance. It also doesn't apply to what are known as conditional primary obligations. I'm not going to go into what a conditional primary obligation is, because frankly life's too short. But the point is, sometimes it's obvious, but sometimes this area can be quite tricky. So again, just check and don't charge headlong, assuming that it's potentially within scope. But if your clause is a secondary obligation, what makes it penal? Well, you need to consider a party's legitimate interest in enforcing performance. That itself requires holistic and detailed consideration of various commercial factors. I'm sure that many university essay and probably doctoral thesis has been written on this topic. So I'm not going to go there because I don't frankly have time this morning, except to say this. The courts basically say it's never a legitimate interest just to punish the contract breaker. So as a sort of extreme example there, the case at the bottom, the Ahuja Investments and Victory Game case, there was a secondary obligation on breach of primary, I think defaulting on payments or something, which imposed a 12% rate of interest, compounded monthly, which gave an effective increase in the rate of 400%. Unsurprisingly, that was held to be extravagant, exorbitant, and oppressive, basically just a punishment. But to use the example from the actual parking eye case, which was one of the subjects of the co-joint appeals, there the customer stayed in one of those shopping centre car parks, which allows 2 hours free parking, but if you overstay the 2 hours, you get whacked with an £85 charge, reduced to £50 if paid within 14 days. So clearly, if you overstayed by a few minutes, or probably even half an hour, £85 or even £50, it's not representative of the parking operator's commercial loss. And that was essentially the old Dunlop pneumatic tyres era test as to whether or not a clause is penal. But in Parking Eye, the courts, I think, at every stage of the appeal, held that what the parking operator did have was a legitimate commercial interest in enforcing that clause to derive some revenue, to allow it to operate the car park and the scheme, to ensure proper management of the car park, and to ensure that customers were incentivized to keep moving on and circulating. And for those who recall Blu-Sky from the start of this talk, that case, there was also a discussion of whether the cancellation clause was a penalty clause. I think it was probably obiter because of the findings on the onerous terms, but the judge did find that it actually was also a penalty clause. So as I say, sometimes these tools can be applied to a number of different situations. So that test, whether or not a clause, secondary obligation triggered, is extravagant or unconscionable in relation to the interest of the innocent party, is probably now in this area where the most subtlety lies. I've said this clearly a number of times this morning, but it is very fact sensitive, and except in very clear-cut cases, it is not the sort of thing that gives rise to a quick or easy answer. So that's it. Thank you very much for your time and attention this morning. I really do hope that was of some use to give you a toolkit of ideas, none of which I'm sure will be new to any of you, but can sometimes be forgotten in practice. I've put my email address there. I always say this, but I really do mean this. Please do feel free to get in touch if anything was unclear, if you have any questions, you have any examples you'd like to discuss, or if you just like to talk about conditional primary obligations. Other than that, it just really remains for me to say thank you very much, and hopefully see you all soon.